Did you know that when you bring a lawsuit seeking money as a form of compensation against a careless doctor, the doctor and his attorney are going to do everything possible to get your case thrown out before you ever get to trial? You want to know how that happens? Come join me on this walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, you decided to bring a lawsuit against your doctor claiming that he was careless and that his carelessness caused you harm and injury. And now your doctor denies all of your allegations and he refuses to accept responsibility for what happened to you. So you have no choice but to see if you have a valid case. You go to an experienced attorney, they evaluate your case, they get all your medical records, they have an expert review it who confirms that yes, your doctor was careless and caused you significant harm and injury. Now, during the course of your lawsuit, which could take 2 years, could even take longer. Now, after the discovery process has completed, after all depositions have been done, after all medical records have been exchanged, after you have disclosed your entire past medical history, now your attorney finally tells the judge, "Judge, our case is ready for trial. We are going to put this case on the trial calendar now." And the judge says, "Okay." But then he's going to say something that you never even considered when you were deciding whether or not to bring this lawsuit. The judge says to the defense attorneys, "Okay, counselors, you now have 60 days in which to make your motions." Now, what does that mean? It means that the defense lawyers can go ahead and try and get your case thrown out if they feel it's appropriate. Now, what does that mean? It's called making a motion for summary judgment. This is an attempt by the defense to try and get your case thrown out before you ever get to trial. All of the effort and energy that you have put in and your attorney has put in over the past year and a half, 2 years, 2.5 years, just to get to the point where you can now say, "Judge, we are ready for trial." First of all, you're not getting to trial that quickly. Second of all, the judge will always give the defense an opportunity to try and make these motions, which is a formal written request to the court to throw your case out. And you might be thinking, wait a second, I don't understand. I have a valid case. I know in my heart of hearts that I have a good case. I know that my attorney has had a medical expert to go ahead and review my case who tells me we have a valid case. So how is it possible that the defense attorneys can go ahead and try and get my case thrown out before we ever get to trial, before I ever get to put my case in front of a jury and let them decide? I'll tell you how. Because the procedure in New York is that once you advise the court that your case is ready for trial, the defense now says, listen, why should we go ahead and have a full-blown trial when the evidence is clear-cut, when the law is clear, that there's no possible way that this injured patient can go ahead and win this case? And they say, "Judge, let us show you." The defense has to put together all of the evidence. They have to compile a detailed, very, very detailed list of what all the facts are in your case. Then they have to get all their medical experts to now come in and support their position that nothing was done wrong. And that if something was done wrong, whatever the doctor did not cause you harm and injury. And then they have to present all of the evidence to the judge on paper. And then you would think, okay, now the judge is going to decide who is right and who is wrong. Well, that's not how it works. Once the defense has accumulated all of their evidence, all of the testimony that has been given before you get to trial, known as pre-trial testimony, depositions, also called examination before trial. And then the defense experts now go ahead and explain in exquisite detail why they believe our positions are totally wrong. Now, what happens after that? After the defense has put in a request to the judge and submitted all of the details that they think he needs and all of the evidence to support that and all of the exhibits, now we have an opportunity to respond to those allegations. And I will tell you, responding to the allegations can literally take hundreds of hours. And that's why we need a significant amount of time to respond to them. It is the same effort as if we are going to trial. The only real difference is that we're doing this on paper. The real difference is that this is not taking place in front of a jury. This is taking place on paper, which means we now have to take all of the things that we would normally explain in front of a jury, and now we have to put it on paper. And the reason we do that is so that we can show to the judge that based upon the detailed facts as we know them to be, that there is no possible way the defense is correct in this particular case. This summary judgment motion is not for the judge to decide who is more likely right than wrong. The judge is not going to come to a conclusion about who should win this trial, who should win this case. The judge is not going to decide whether you, the injured patient, are entitled to receive money as a form of compensation for all of the harms and losses and damages that you incurred. That is not the purpose of this summary judgment motion. The purpose of this motion is for the defense to make every single effort possible to get your case thrown out. Now, how do we actually prevent the defense from getting your case thrown out? Well, what we have to do, what our primary obligation when responding to these allegations, when responding to this motion is, we have to show the court that there are clear disputes, that there are factual issues, material issues in this case that cannot be resolved by the judge. You see, the judge is supposed to look at these papers, supposed to look at the evidence and decide whether there are only issues of law to be decided. If it turns out that one of the key issues is that the doctor failed to tell the patient about the various complications, and now the doctor argues, I told the patient all these things, and the patient said, no, the doctor didn't tell me any of these things. That's what we call questions of fact. It'll be up to the jury to decide who is more credible, who is more believable in that instance. And if that were the only issue in the case, the judge would have no choice but to deny the defense's request to throw your case out and now allow your case to proceed toward trial. Why? Because it is the jury's function to decide who is more likely right than wrong. It is the jury's function to decide who is more believable, who is more credible. That is not for the judge to decide. By the way, not every doctor, not every person that you sue is going to ask the court to have your case thrown out. Before going ahead and making this request to the court, the defense attorney is going to make an analysis, make a risk analysis to determine what is the chance that the judge is going to turn around and say, sorry, you lose this motion because there are clear questions of fact. And if the attorney, the defense lawyer, determines that there are clear questions of fact to be decided by a jury, there's no point in him making this motion, in him spending literally hundreds of hours of his time and effort and energy to try and get your case dismissed if he knows at the outset that there is virtually zero chance that the judge is going to agree and throw your case out. So why do I share this quick information with you? I share it with you because I've just had to deal with seven different summary judgment motions over the past 3 months based upon different defense lawyers on different cases who have decided that they were going to do everything possible to try and get our clients' cases thrown out before they ever get to trial. You know, I realize you're likely watching this video because you wanted to see the beautiful scenery here on the beach. No. I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter happened in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.